So the Supreme Court has recently decided a case called Trump versus US that basically held the president is entitled to a rather broad criminal immunity for official acts conducted while in office. Now, this ruling has been used to attack Trump as being unfit for office, as well as attack the Supreme Court for being thoroughly corrupted by politics, and accuse the conservative justices of doing everything in their power to protect Trump at all costs. I mean, just take some of the commentary community's responses. Legal Eagle, who's one of the biggest attorney YouTubers on the entire platform, his video on this case is called Trump is Immune, and his thumbnail is a picture of him looking really worried and stressed, pictures of Trump with a crown on his head because he's a king now, and just 2 words on it, saying, "We're And then if you watch the video, he says this is one of the 5 worst decisions of all time, which for those keeping score at home, that includes Plessy versus Ferguson, which allowed separate but equal to be constitutional, Dred Scott, which returned an escaped slave back to his slave owner, although he had escaped and made it to a free state, Korematsu, which allowed the internment in concentration camps of American citizens with Japanese ancestry during World War II, and Buck versus Bell, that allows the forcible sterilization of mentally incompetent people. So according to Legal Eagle, I guess this would be number 5 with those other cases. But it doesn't stop there, because we can also take Destiny, who is a large YouTuber streamer who talks about law and politics on his YouTube channel. In Destiny's video on this case, he basically calls this case the beginning of the end of democracy.
Initially, it seems like a really big deal of a ruling. And then when you look at it a little bit more and you think about it, it's probably not actually that big of a deal. But then when you look into it a bit deeper, I think it is maybe the beginning of the unraveling of our democracy.
But it's understandable that the commentary community is responding this way, because this is how the dissent characterized the majority opinion. Justice Sotomayor, writing in the dissent, strikes a major tone of doom and gloom, saying the president is now free to assassinate his political opponents and organize military coups and do all that without any fear of repercussion or accountability for his actions. And that at the end of her opinion, she says she dissents with fear for our democracy. But as I'm about to explain in this video, the majority's opinion actually does make sense. Sure, it can feel frustrating or unfulfilling in certain parts of it, but in the end of the day, it does follow logically and legally, where by comparison, the dissenting opinion is just chock full of extreme exaggerations and sometimes even outright lies, where she accuses the majority of doing something it didn't do, or accuses the majority of not doing something they did do. The dissent is so unhinged in some parts that it makes you wonder if she even read the majority opinion before writing her dissent. But I'm getting ahead of myself. All I'll say now is that if you watch this video all the way to the end, you're going to know everything you need to know about this case from the case itself, because I'm going to give you direct quotes from the case. I'm not just going to give you my opinions. I'm going to cite the case directly, let you see it for yourself, so that way you can make up your own mind on whether the majority is correct or the dissent is correct. So what's up, everybody? Welcome back to the channel. My name's Scotty O, aka the Gen Z Attorney, and I currently work as an assistant district attorney in the great state of North Carolina, which means I'm currently a prosecutor. I work in the courtroom, and I'm in court every day, and I'm trying to put bad guys in jail. And on this channel, I make videos talking about the criminal law, but also the constitutional law. And my main goal is just to try and elevate the discourse, make it more knowledgeable, make it more informative, so that way when we're having debates on major issues like this case, we can just be more informed and have better discourse and better dialogue about it. So if you like this kind of content, then I would hope you would drop a like down below to let me know that you do like it. And if you want to see more, then subscribe to come back for more. But without further ado, let's jump right into Trump versus United States. So the first thing I'm going to do to understand this opinion is explain exactly what framework the majority created and when immunity applies to a president, because as we're seeing a lot, the attacks against his opinion are saying that the majority has created a king above the law in the presidency by making him absolutely immune from basically everything. But as the majority explicitly states in their opinion, their holding does not place him, being the president, above the law. To understand where they're getting that from, you have to understand the 3 buckets of immunity that the majority created here. That first bucket is an actual absolute immunity, and it applies to core presidential functions, a narrow core, think of it like the center, the narrow core of presidential functions within the conclusive and preclusive constitutional authority of the president. Basically, the president is vested with some exclusive powers that no one else in the government has. They belong to the president and the president alone. In fact, the majority references them as being in the Constitution, Article 2. Powers like the pardon power, or the appointments power, or the recognition of a foreign state power. These are all exclusive presidential powers, and any use of those powers by the president is going to be absolutely immune from prosecution. So that's the first bucket of true absolute immunity for that narrow core of presidential power. The second bucket is the most controversial, the most debatable. It's that of presumptive immunity. Basically, the Supreme Court held that while there's absolute immunity for the core, if there's an official action that takes place underneath the broad umbrella of presidential authority, there's going to be at least a presumptive immunity, with the standard being, right, is it manifestly or palpably beyond presidential authority? If it's not, then it is an official action and therefore has at least a presumptive immunity. But with any presumption, the presumption is rebuttable by the prosecution showing that their investigation and prosecution would pose no dangers of intrusion on the authority and functions of the executive branch. So yes, while it is a presumptive absolute immunity, that presumption can be rebutted by showing that the use of official power exceeds the authority and function of the executive branch, despite it being an official act. Assuming the prosecution can meet that burden, the presumptive immunity will be stripped, and that act, even if it's an official act, will not be immune and can therefore be prosecuted. So that's the second bucket of presumptive immunity. And finally, the third bucket is just no immunity. It applies to private or unofficial acts. So that standard we had earlier, the manifestly or palpably beyond presidential authority. If an act is manifestly or palpably beyond presidential authority, then there's no immunity for that action, which makes the president fully prosecutable for any private or unofficial actions. That is the framework right there. That's the entire thing of what the majority created for presidential immunity and when each bucket applies to presidential conduct. Okay, now that we understand the framework of what was created, we now have to understand the rationale behind the framework and why each bucket was created and why it was given the standards and definitions that they were. And beginning first with the absolute immunity bucket, this one's pretty easy because both Trump's team and the government's team, and even the majority in dissent, all agree, everyone's in agreement that there should be absolute presidential criminal immunity for core presidential functions. As I said, both the government, which was arguing against immunity, even they conceded during oral arguments that they would not disagree with this position, even though Justice Sotomayor still attacks this majority position as being unnecessary considering the facts of the case. Even she says there's intuitive appeal to an absolute immunity for core presidential functions. So yeah, everyone's in agreement. That's why this first bucket exists. Skipping over the second bucket into the third no immunity bucket, this one's also easy because once again, everybody agrees. Even Trump's team conceded that there's no presidential criminal immunity for private, unofficial, aka non-presidential acts. Now, once again, despite everyone being in agreement about this position, the dissent still feels the need to attack it by calling it unremarkable proposition that's no real limit on today's decision. Even though, if you read the majority's opinion, you can see when they talk about the 4 instances of conduct in the indictments, they say that arguably 2 out of the 4 fall in this bucket of no immunity. I'd say that's hardly unremarkable, but is just in line with the dissenting opinion that seems to not even know what's happening in the majority opinion. But either way, as I said, everyone agrees there's absolute immunity for core presidential functions, and everyone agrees there's no immunity for private, unofficial functions. So that just leaves the one that everyone's fighting about, the middle ground, the presumptive immunity bucket. Now, the majority based their creation of this presumptive immunity bucket on the balancing test that happened in Nixon versus Fitzgerald. Now, the quick rundown on Nixon versus Fitzgerald, that was the original presidential immunity case where President Nixon was being civilly sued for wrongful termination by an Air Force airman. And in that case, the Supreme Court initially held that presidents are entitled to absolute civil immunity, based on a balancing test that balanced the interest in the person trying to sue the president versus the president's interest in the effective discharge of government, and essentially a right to not be bothered by vexatious or unnecessary lawsuits. So using that balancing test, the majority in this case found that despite there being a compelling public interest in litigation in holding a president accountable for crimes committed against the public, keep in mind that word compelling is strong. That's the highest interest you can have in for example, a strict scrutiny context. Strict scrutiny is the highest standard of review for the Supreme Court, and the only way an action will survive strict scrutiny, in part, is if it is serving a compelling interest, which is unbelievably high burden. So the majority here is conceding that there is a compelling public interest in being able to criminally prosecute a president for criminal conduct. However, they say that compelling interest is outweighed by the potential chilling effect that the specter of a criminal prosecution would pose on a president in his attempts to effectively discharge his duties and function the executive branch. And they ultimately use 3 rationales for saying the intrusion on the president would be too great. Now, the first rationale goes back to the framers and the agreement among them that the president needs to be an energetic and fearless executive. This is quoting from Federalist 70, written by Alexander Hamilton. Of course, this is one of the main problems with the Articles of Confederation, was that there was too weak of a centralized government. And while yes, we had just fought a revolution to escape a government that was too centralized, in that case in a British king, the first attempt at a US government made things too decentralized. And so in arguing to create the Constitution, they're arguing for a middle ground between too much centralization and not enough centralization. And one of the main arguments here is that the president, the chief executive, has to be an energetic and fearless decision maker. So right, they pull that from Federalist 70. They also pull that from Clinton versus Jones and a case called Seila Law. So that's the first rationale, is the framers' intent. The second goes back to the civil immunity precedent I talked about in Nixon versus Fitzgerald, where they were concerned about, with the specter of litigation always hanging over the president because he's not immune, that would cause a president to be unduly cautious in exercising his duties. In considering the framers' intent and having an energetic executive, they don't want a president to be this type of unduly cautious. They want him to be bold and fearless and unhesitating in his action. That's right, we've got framers' intent, we've got prior Supreme Court precedent upholding civil immunity, and then the third rationale here is the fact that the Supreme Court has found presumptive immunity in the past for presidents to withhold certain internal documents, memos, communications from turning them over to prosecutions of other people that are not the president. Two main examples here were the criminal prosecution of Aaron Burr for killing Alexander Hamilton, as well as United States versus Nixon. Both of those cases allowed both presidents to defy subpoenas, to an extent at least, from turning over personal internal communications that would be probably protected by executive privilege. With the majority here reasoning that if the intrusion was too great in those two cases, the intrusion of just turning over some internal documents, that surely a president who himself is now facing criminal prosecution, where the government is now seeking to try and imprison him, surely that is a greater intrusion than just turning over some papers. So that's the main argument for why the majority is coming down on the side of the balancing test that they did, where, right, despite conceding there is indeed a compelling public interest in the criminal prosecution of a president for criminal conduct, the risk of intrusion into the executive branch, into the presidency, is essentially too great of a risk that would cripple our entire functioning of government, essentially. And that based on the framers' intent, as well as cases that have happened since then, there is historical and legal basis for granting some immunity to prevent that type of intrusion. So that's the majority framework, and that's the majority's rationale behind that framework. Now we move to the dissent and their attack on those rationales, and really on the framework itself. And the most important thing to note about this dissenting opinion is that Sotomayor is arguing that there's effectively no meaningful difference between the first and second buckets, which means her arguments here are essentially just arguments against immunity for official acts, which means in her view, the majority has granted the president absolute immunity for all official acts. Of course, as we've already been over, the majority themselves would say, no, we've given absolute immunity for core acts and presumptive immunity for the rest that fall under the broad umbrella. But right, according to Sotomayor, there's really no meaningful distinction, so the president has absolute immunity for all official acts, and then bases her entire dissent on attacking that immunity, as she says, atextual, ahistorical, and unjustifiable, as well as being utterly indefensible. Now, I'm going to go pretty hard on Sotomayor and her dissenting opinion. I'll say this up front, she does make some good points throughout it, but unfortunately the rest of her dissent is just so categorically unhinged that it clouds the actual good point she's making and makes the entire thing just look insane. But yes, moving to her attacks here, beginning with her calling the majority's opinion atextual, she's basing that on basically saying that there is no immunity clause within the Constitution that grants the president any type of immunity, and therefore, if the immunity clause does not exist, immunity does not exist. If you're going to say that there has to be a textual hook explicitly granting immunity, then you would have to argue that Nixon versus Fitzgerald was wrongly decided. But she doesn't argue that. In fact, she defends it as being correct. So for her to say Fitzgerald was not atextual, but this opinion is atextual, is just flat out inconsistent. I would note here as well that this is an example of her accusing the majority of not using the text in their analysis despite claiming to do so, which is just flat out disproven by the majority itself because they explicitly reference Article 2 when talking about the types of powers that the president is immune for exercising. But that's just the first accusation of hers that turns out to be totally false. Moving now to her attack as the majority opinion being ahistorical, this one has some merit, where she does have her own historical examples that do show some framers contemplating that the president is subject to prosecution. However, the majority standard does not foreclose on the possibility of prosecution. Therefore, the majority standard is also consistent with her historical citations of people like Hamilton, people like Pinckney, claiming that the president is subject to prosecution. Yeah, the majority agrees. If the president does something that's unofficial, or the president does something that's outside the authority and function of the government, even though it's an official act, he's fully prosecutable for those. So the majority's framework is consistent with historical examples saying the president should be open to prosecution. She also cites more contemporary cases like Nixon's Watergate or Reagan's Iran-Contra scandal as those investigations proceeding on a common understanding that the president could be criminally prosecuted for his conduct if it were illegal. And because there's this common understanding that everyone had that the president was not immune, therefore that makes this decision, as she said, ahistorical for finding such immunity. But once again, the majority standard does not foreclose on the potential of prosecution. It is notable that both Watergate and Iran-Contra never got to the level of a criminal indictment and therefore never required the Supreme Court to rule on whether the president was criminally immune. So just because there was a common understanding does not definitively say whether something was one way or another. But if we take both Watergate and Iran-Contra, there were official actions, yet true, being official, but likely exceeded the authority and function of the executive branch and therefore could have the presumptive immunity stripped away. So once again, the majority's framework is consistent with her examples of Watergate and Iran-Contra. Which takes us next to her attack of it being unjustifiable and utterly indefensible. And to do that, she attacks the standard that was given for presumptive immunity, which is the prosecution can proceed so long as the prosecution can prove that their investigation would pose no dangers of intrusion on the authority and function of the executive branch. Now, she really hones in hard on that first half, the no dangers of intrusion, to say, well, of course there's going to be intrusion. How can there not be an intrusion? And using that as her basis for saying that there's no meaningful distinction between absolute and presumptive immunity, because so long as there's a danger of intrusion, the president's going to be absolutely immune. But the only problem with that analysis is it cherry picks the first half of the standard while totally ignoring the second half. Well, yes, the standard is there can be no danger of intrusion. That danger of intrusion has to be against the authority and function of the executive branch. Now, I'll admit on this part, maybe I'm reading into this my own definitions, but when I read that authority and function, I'm interpreting that as valid authority and function, because I don't see how the Supreme Court can say that there can be no intrusion on an invalid authority and function. By that point, you have gone now manifestly and palpably beyond a president's authority because the authority is invalid. So built into this standard of authority and function is the implication that it has to be a valid authority and function. And so yes, if there's a danger of intrusion on a valid authority and function, the president's going to be immune from that investigation. But if we're using the examples that she cites herself, like the president assassinating a political rival or the president organizing a military coup, is any of that a valid authority and function of the presidency? Everyone can agree it's not, which explains why the majority feels that their decision has not put the president above the law, because they still leave that door open for a president who exceeds his valid authority and functions to be prosecuted, even for official acts. But right, Sotomayor completely leaves out that entire back part of that analysis. She only focuses on the danger of intrusion to say, well, since there's always going to be a danger of intrusion, the president is now absolutely immune for everything. See, it's like a math problem where you have to do like 10 steps to solve the equation. If you get the first step wrong, but get the next 9 steps right, your answer is going to be totally flawed all the way through, even if your math was right. So her initial premise here, that solely based on this danger of intrusion standard, and the fact that there will never not be an intrusion, that misstep right at the beginning causes the rest of her analysis to be utterly flawed and misguided. And that's really the core of why her opinion is so far out there. Because if we assume that as true, that it truly is just a simple no danger of intrusion standard, then yeah, everything she's saying is right. The president has become absolutely immune for all official acts. But she's not right, and that's the most important part here, and why her opinion is just so unhinged. But moving on to more of her arguments about why the majority is utterly indefensible, she cites the same balancing test from Nixon versus Fitzgerald that the majority uses. Except, in her view, that balancing test should yield the exact opposite result. Now, of course, if you remember from earlier, the balancing test basically pits the public interest in the litigating parties. So in this case, it would be the public's compelling interest in holding a president accountable for criminal action. It's balancing that interest against the dangers of intrusion and the effective functioning of the executive branch. Now, once again, ironically enough, she accuses the majority of putting all of its weight on the intrusion piece of that balancing test, saying there'd be too much intrusion, and citing back to the framers' intent, the civil immunity case, and the prior examples of allowing the president to withhold documents as their examples of that. But in her view, they put all their weight on that while totally discounting and discrediting the public's interest. But once again, that's just not true, because the majority explicitly stated the public has a compelling interest, which is the highest standard of it, that an interest can be. And then while she is accusing the majority of putting all their weight on one side while ignoring the other side, ironically, she's doing the exact same thing in her analysis by putting all of her weight on the public interest side while hand-waving away the dangers of intrusion or the unique risks that a president could face in a criminal prosecution. Yeah, in her dissent, she simultaneously admits that a president faces a unique risk of political bias polluting his prosecution, but then claims that the president really has nothing to worry about the danger of intrusion because there's robust procedural safeguards like grand juries and evidentiary rulings and jury instructions that would all serve to protect the president from any and all risk of bias. So she's trying to have her cake and eat it too, saying there is simultaneously no risk whatsoever facing the president, but there's also unique risk of political bias polluting his prosecution. So on top of her hand-waving away the majority's concerns about the unique risks the president could face, that's the majority's first argument. The majority's second argument, and actually this is the majority's main argument that is a theme throughout their entire opinion, and is the theme that they end off with in their final paragraph, is this risk of the executive branch cannibalizing itself. And this is really important. If you take nothing else away from this video, I want you to take this away. The majority is hyper concerned with what they're seeing is a risk of political prosecutions becoming a mainstay in American politics, where one president will take office and then use his office to prosecute his predecessor for any crime he can go find, any crime he can come up with. And then once that president leaves office, the next president will do the same back to him. And this is uniquely dangerous because the executive branch is the one responsible for prosecutions. And even though the people within the branch will come and go, the branch itself maintains the same function. And the majority is ultra concerned with this cannibalization happening of this nonstop back and forth using the trappings of the office to prosecute the other side. I mean, the majority even cites George Washington's farewell address and his talk about avoiding a cycle of one faction dominating another and then vice versa into infinity. And if the president has no immunity for official acts, then the president is going to be fully subject to criminal prosecution by politically motivated rivals. Now, I'm saying all this to say this is a huge concern. Arguably, the biggest concern that the majority has is a cycle of prosecution of rivals that would ultimately cause the executive to cannibalize itself. I'm going to refer back to this as the cannibalization question. And I give all that setup to say Sotomayor does not address this one time. This concern that the majority cites when they're directly addressing the dissent in the majority opinion, Sotomayor in her dissent refuses to address this question. She is solely focused on the specter of a president just feeling empowered and buoyed by the knowledge that he'll be immune for any criminal act he takes. The majority actually does address that part by saying, well, yes, the dissent points out these examples, extreme hypotheticals of a president who just decides to start flagrantly violating the law, but then says the likelihood of that happening is far less than the likelihood of this cannibalization happening. And so the fact that Sotomayor does not address cannibalization whatsoever at any point in her opinion, I think is so telling of the analysis there and the refusal to actually engage with what the majority did, and instead choosing to just grandstand and create hyperboles and create the most extreme examples she can possibly think of to try and build this narrative that the majority is just doing Trump's dirty work. So yes, her failure to address this cannibalization question is so telling for where she stands on this opinion. But with that said, that concludes the rationales, at least the competing rationales, regarding the framework that the majority created. Now that we understand the framework and the rationale behind the framework, we have to understand kind of what that does to this case and what that does to this whole situation moving forward. Because with this framework created, there must now be fact-finding on what is called the categorization question, where basically you have to categorize all the alleged conduct into either official acts or unofficial acts. And since the Supreme Court created this new framework, the lower courts did not have this framework to operate off of, which naturally means that the Supreme Court's going to have to remand the case to the lower courts for more fact-finding and determining whether the conduct is official or unofficial. Yeah, this might feel unfulfilling as a viewer, as an observer, but this is common Supreme Court precedent. I mean, the dissent cites a case here where it's Supreme Court protocol to confine the opinion only to the very questions necessary to the decision decision of the case, quoting Dames and Moore versus Reagan. So right, common protocol, remand the case down, because the Supreme Court is not a fact-finding court. The Supreme Court is a court for the interpretation of law. It's the lower court, the trial court, that is the finder of fact. And especially since immunity is a threshold question, it has to be decided in the trial court whether or not there are facts to support a finding of immunity or no immunity. Since that's a threshold question, yeah, that has to be answered first at the lowest court level and then go from there. Now, I've seen some people, including the dissent, pointing out how this is inconsistent or intellectually bankrupt of the majority to do because they still answer some questions of immunity. For example, saying that Trump talking with the Department of Justice officials, that is absolutely immune, while leaving the rest of it for the conduct that is arguably possibly unofficial and therefore not immune. Instead of the Supreme Court just definitively saying that, they remand that for the lower court to determine. Now, yep, while that appears to be inconsistent, like why would they decide one issue and not the rest, that once again is Supreme Court protocol. As far as the absolute immunity question, that's a question of law and whether or not the given facts fall within a core presidential function. The majority stated here that Trump talking to his team, talking to his Department of Justice, that is a core presidential function. There's no additional facts that need to be found because the facts are given, the facts are stipulated to, that Trump was talking to DOJ officials. And since there's no more facts to be found, a ruling on an issue of law is fully justified there. Now the rest of it, whether Trump talking to Pence and pressuring him to reject the elector slates, as well as the false elector scheme and the ellipse speech, there's just more facts to be found on whether or not those are official or unofficial, which is why the majority remanded it. But all that to say, that's why the case is not over yet. That's why the case got remanded in the way that it did. Now, another concern I've seen thrown at the majority opinion is the fact that they created this prohibition against using official acts evidence in order to prosecute unofficial acts. Now, of course, here being the official acts conduct is immune from prosecution, and because of that, the majority here does not want this immune conduct to then be used to bolster prosecution of not immune conduct. Because of the risk that the jury can look at the immune conduct and say, well, we don't like that. He might be immune from that, but we don't like that he did that, so we're going to let that weigh on our decision on whether to convict of this not immune conduct. Now, that certainly can feel frustrating considering the potential for this possibly hamstringing prosecutions of unofficial acts, but it actually does make logical sense and is in line with evidentiary rules. Now, the first of these rules is 404B, which prevents the use of character evidence to basically prove that this person is just a bad person and therefore deserves to be convicted of what they're charged with. Now, how this plays out, let's say in the real world, let's say I've got someone in my courtroom who's charged with simple assault, but then on their record, they've got prior DWIs, they've got prior trespasses, they've got many different priors, but none of them have to do with the current simple assault. The idea of 404B is we don't want to prejudice the proceedings by letting in all this litany of prior bad things that he's done to just prove that this is just a bad guy. And we may have no evidence of the simple assault, but he deserves to be punished based on being a bad guy. 404B is designed to hone in a prosecution onto the conduct at hand and make the jury focus on that conduct and whether or not there's sufficient evidence to prove that conduct actually happened. So that idea does play in here where we don't want to distract the jury. We don't want to prejudice the jury by showing them other conduct which may be very bad. But at the end of the day, that conduct is not what's on trial here. We want to get the jury to focus in on the unofficial conduct for which they have to determine whether there is sufficient evidence to prove beyond a reasonable doubt that the president will be guilty of. So 404B applies. I would also say 403 applies, which prohibits the use of any evidence that is more prejudicial than it is probative. Similar rationale here. We don't want to be prejudicing the jury with conduct for which the president is immune, even if there's some probative value there, because really the risk of prejudice is too great. Now, the dissent tries to say that we should be able to use official acts evidence to prove unofficial acts because the court can limit the jury in what they hear with jury instructions. They can do evidentiary rulings. It's all wrapped into their argument about the robust procedural safeguards that they simultaneously say give the president no cause for concern while also admitting that the president is uniquely at risk in a criminal setting due to the political biases of just people generally. But either way, the reason the dissent's argument for saying that evidentiary rulings and jury instructions are enough, the reason that it's not enough is because when it comes to prejudice and prejudicing a jury, it's this idea that you can't unring the bell. You can't put the toothpaste back in the tube, which is especially prevalent here considering a prosecution of a president will undoubtedly have politics playing an influence. The last line of attack I've seen lobbed at this majority opinion is this idea that the majority granted Trump all of the immunity he asked for and more. Now that's a direct quote from the dissenting opinion, as well as basically all of the online commentary community. But once again, this is just simply not true, and we know that because we know what Trump asked for, and we know what he was given. Now, the first thing Trump asked for was absolute immunity for everything unless he was first impeached by the House and convicted by the Senate. The majority quickly shot that down. They said it's ahistorical, there's no basis in the text for it, there's no basis in history for it, that's just not a valid argument whatsoever, and they denied it. So already, one of the two things Trump asked for, denied. We're already at a point that's lower than what Trump asked for. Then if you move to the second thing Trump asked for, he asked for absolute immunity for all official acts as president. Now, it's true, the majority did grant an absolute immunity to a narrow core of conclusive and preclusive acts, which, once again, the dissent agrees with, said there's an intuitive appeal to that position. The majority then granted presumptive immunity to the rest of the official actions that are not manifestly or palpably beyond the president's authority. So yes, presumptive immunity for all the rest of the official acts, but that presumption can be overcome if there's no intrusion on a valid executive authority or function, which, as I've been over already, that can be rebutted. Assassinating political opponents, that's not a valid authority and function of the executive. Military coups, not a valid authority and function of the executive. So this presumption can be rebutted. Is it going to be easy to rebut? Maybe not all the time, but it certainly can be rebutted, which makes, once again, the dissent's argument that there's just absolute immunity for all official acts not true. But going back again to what Trump said, what he asked for, that is what he asked for, and even by the dissent's reading, he was basically given what he asked for. So the first thing he asked for was denied, and the second thing he was asked for, he was given, according to the dissent. So even by the dissent's own reading, he was given less than what he was asking for. And by the majority's reading, he was given much less than what he was asking for. So whichever way you slice it, Trump was not given all the immunity he asked for and more. That is just an outright lie. So with all that in mind, that leaves me with the last thing I want to do in this video, which is really tackle Sotomayor's dissent directly and just go through each piece and just explain every which way in which she is exaggerating, she is lying, she's accusing the majority of doing things they're doing or not doing. I just wanted y'all to see how unbelievably insane and unhinged this dissenting opinion is, which is unfortunate because, like I said earlier, she makes some good points in there, some valid points that I wish the majority did a better job, for example, explaining the compelling public interest in a prosecution. But any valid point she makes is just consumed by the cavalcade of nonsense that she's just dropping every single paragraph. I'm just going to do one last run through of the discrepancies, of the oddities, of the hypocrisies of this dissent, so you can just understand what we're dealing with here. So of course, if you remember, she accused the majority of only favoring one side of the Fitzgerald balancing test, despite the majority conceding that there is a compelling public interest. But then after accusing the majority of doing that, she does the exact same thing the opposite way by only favoring the public interest side, while simultaneously conceding that the president would face a unique risk in a criminal prosecution, but also would face no risk at all due to the procedural protections in place. And on top of that, which once again, this is my most important point in this entire video, she never addresses the cannibalization argument. And this is despite the majority explicitly referencing that argument in their response to her dissent and in their closing paragraph of their opinion. It's the biggest concern that the majority is wary of, that they don't want to see this endless cycle of prosecuting political rivals because of what that could do to our country. She never even references that argument. That's that. But she also accuses the majority of claiming to cite the Constitution while not citing to it at all, according to her, which, once again, it's an outright lie. The majority references the Constitution explicitly when referencing Article 2 to define some of the core presidential powers that the president has. So right, that's just an outright lie. Next, she attacks the majority's position for granting absolute immunity for core presidential functions, while conceding herself that there is an intuitive appeal to that and never actually saying that that's wrong. So she's just unnecessarily attacking the majority. She accuses the majority of being atextual and ahistorical because they invented immunity out of thin air in this case, but then defends Fitzgerald as being properly decided and does not call for it to be overruled, even though that case did the same thing by inventing immunity out of thin air. On top of that, as I just recently said, she accuses the majority of giving Trump all the immunity he asked for and more, despite by either the majority's reading or the dissent's reading, Trump was given either the same immunity he asked for or less. In all likelihood, he was given less immunity. So that's just another lie. She next accuses the majority of creating a law-free zone around the president since presumptive immunity prevents intrusions, but fails to address the second half of that standard. The standard is not simply whether there's a danger of intrusion, it's whether there's a danger of intrusion on a valid authority and function of the president. Once you include the full standard, you can see the presumption can definitely be rebutted, which makes her entire argument fall apart. Next, she accuses the majority of judicial activism by determining that some conduct is official, but remanding the other conduct that could be unofficial. Once again, this is wrong because the Supreme Court is not a fact-finding court. If there's an issue that the facts are already decided on and it's simply a question of law, then the Supreme Court can decide that. But so long as there are still questions of fact to be answered, then yes, it must be remanded for the facts to be found. And again, her accusation isn't even true on its face because the Supreme Court majority strongly implies that at least 2 of the 4 instances of conduct are likely not official. So that's half of the conduct in the indictment. She's also mad about Trump's pressure on Pence not being clearly unofficial because in her mind, Trump pressuring Pence to overturn an election, that is unofficial. Okay, fair enough. Under that reading, sure. But the majority provides more info and more context and more nuance by saying, well, yes, in that specific case, if it were in a vacuum, that would be true. But we're not deciding just this case, we're deciding this case for the ages. And it is true that the president works with the vice president, not only as his hype man, as his wingman in the executive, but also as the president of the Senate, as a legislative function. The majority points that out and points out how it could be official conduct for the president to be communicating with the vice president about a legislative agenda. All the majority said is it makes it less clear, makes it debatable on whether Trump's pressure on Pence was official or unofficial. But she gets mad at that because this additional context weakens her point. But I guess this is a pattern we're seeing already, where she's more than happy to cherry pick specific examples that, if existing in a vacuum, would prove her point. But then when you actually put the full picture on the role and the relationship between a president and a vice president, the full context weakens her point. Instead of actually addressing the full context, she just decides to get mad that anyone would even offer the full context. So right, it's just ridiculous what she's doing. And finally, she accuses the majority of not addressing why the existing procedural protections are sufficient, but then literally cites their argument that his position puts him in a unique risk in an attempt to just, once again, hand wave that idea away as not mattering due to the safeguards in place. So all in all, that's just what I could find about the dissent, where she's just basically flying off the handle, accusing the majority of doing things that they didn't do or not doing things that they did do, all the while using the most hyperbolic, inflammatory language about the end of democracy and the assassination of political rivals. And yeah, I've said it before, and when I first read this case, I wasn't sure if this was true or not, but now I'm definitively and firmly stating, right, this is just an unhinged, out-of-control dissent, and it should be treated as such. Which brings me now to my final thoughts in this video, and I know it's been a little extensive, but I really wanted to give you all the receipts, as much factual support, textual support as I could from the opinion itself, so you can, like I keep saying, make up your own mind about it. But in summation, in conclusion, I do believe the majority laid out a cohesive, albeit sometimes frustrating framework regarding this idea of presidential criminal immunity. Now, as I stated, the core framework is largely uncontested because both sides agreed on absolute immunity for core functions and no immunity for unofficial functions. The real debate here, the entire debate actually, is about this idea of presumptive immunity, specifically what it is, when it applies, and how this presumption gets rebutted. And yeah, in articulating these questions, there's certainly some frustration. I definitely wish the majority would have done more in addressing the compelling public interest in holding a president accountable for criminal acts, and it also doesn't feel good that a flagrantly illegal official act cannot be used to prove an unofficial act. And right, to an extent, it's true that there is a law-free zone that exists around the president for which he cannot be criminally prosecuted. But just because there are some frustrations here does not render the entire case improperly held. Yeah, despite the majority's brief analysis on public interest, at least there's an acknowledgement that the interest is compelling, which is the highest legal standard possible, but the interest ultimately just does not outweigh the risk that is the destruction of the entire governmental system. As for this impact on the rules of evidence, the rules of evidence do actually counsel against the use of evidence that would unfairly prejudice a case. And also, none of this is to say that a flagrantly illegal act would not have its presumptive immunity stripped under the presumptive immunity analysis. And finally, the first check on a lawless president, according to the framers, has always been impeachment, which continues to exist as it was. And if impeachment fails as a check, then we, the people, the voters, will always have the final check, the final say in our power to not vote in a flagrant criminal who is clearly abusing his office to the detriment of everybody else. I mean, let's be honest, criminal prosecution is a check, but it's just one check. And this wailing and gnashing of teeth about its reduction in our constitutional scheme seems to utterly disregard our other checks in the legislature and in the electorate. If we truly cannot have enough faith to trust the people to not vote for the flagrant criminal, then unfortunately I just think the American experiment is over. So despite there being some understandable frustrations with the way the majority was written and some of the ramifications moving forward, it still is a logically and legally consistent opinion. In light of the majority's opinions, Sotomayor's dissent is largely just straight up unhinged and unfortunately obfuscates some of the actual good points she makes. Like I've already conceded, I think she makes some good historical citations that show the framers' intent to subject presidents to prosecution, as well as contemporary understandings of the same, and I also agree that there should have been more analysis on the compelling public interest by the majority. But even that second point is betrayed by her own analysis of the same balancing test, where she does what she accused the majority of doing, but far worse, by giving no credibility to the other side, other than to hand-wave away this unique risk argument as unimportant, and then completely ignore the cannibalization argument despite being explicitly called out by the majority. This pattern of flawed analysis paired with unhinged rhetoric about how the president is now free to assassinate his rivals and coup the government without any fear of consequence is rampant throughout her dissent. And once again, she repeatedly accuses the majority of either doing things they clearly did not do, or vice versa, accusing the majority of not doing something they clearly did do. If we didn't know any better, you would think she didn't even read the majority's opinion the way she wrote her dissent. She's conveniently cherry-picking parts of what the majority does so she can spin it into a negative without discussing the full context of the majority's holding. And then she even gets mad when the majority does point out the full context because it cuts against the narrative she's trying to build. All that to say, I think the majority is hyper aware of the circumstances surrounding Trump right now regarding this case and the fact it was extremely expedited to get it up into the Supreme Court to have a ruling on presidential immunity. I mean, it was 5 months from start to finish, which is just insanely fast. And on top of this case, I think they've also taken note of the New York hush money case and the circumstances surrounding that and how that was effectively spun up into a conviction for political purposes with some Frankenstein stitched together theory that really should not have held up in court. I think the majority is seeing that and seeing these uses of the judicial system as the first step towards this cannibalization that they are so worried about. Now, what's the best way to avoid this cannibalization when you've got irresponsible actors that are willing to prosecute political opponents? It is to render the president largely immune for official acts, while still leaving the door open to strip immunity from those official acts if they're outside the valid authority and function of his office. Effectively, they just codified this long-held unwritten rule that you just don't prosecute your opponents. While Sotomayor called the immunity a loaded gun lying about to be used by a criminal president, in a way, she is kind of right. But only if the loaded gun she's referring to is a BB gun, which was placed there in exchange for removing the sawed-off shotgun that was sitting there, which represents the transformation of a politically neutral justice system into a partisan tool for exacting retribution on your rivals. By the majority removing this prosecution power from both sides, the majority has placed the responsibility for holding the president accountable in the two main places that it always has been. First being Congress through impeachment, and second being the voters at the ballot box. If those two mechanisms are truly not enough to constrain a flagrantly criminal president, then the American experiment is simply dead. But if we're being honest, that was always the American bargain from the founding. When Benjamin Franklin was asked what the framers did at the Constitutional Convention and what type of government they created, he famously said, "A republic, if you can keep it." The American experiment was always predicated on this notion that the people would be ultimately responsible for the continued survival of the experiment. And that has held true through 250 years. We're the longest standing democracy in the world, and we've survived crisis after crisis, including even an entire civil war. So that's really what I see this opinion as doing, is trying to nip in the bud a potentially destructive path by disarming both sides from politically prosecuting the president, and instead relying on Congress and the people to hold the president accountable. And when it comes to siding with or against the American people, I'm going to side with them every time. But that's really all I've got to say. I hope you enjoyed this video. I really tried to be as thorough as I could and give you the best understanding possible. So if you like that, be sure to drop a like down below. This video took more time to prepare than any video I've done before on this channel. And if you like this kind of content where we talk about the criminal law and the constitutional law, then be sure to subscribe to come back for more. And last but not least, I want to hear your comments down below. Let me know if you think I got this right. Am I misrepresenting either side? What do you think about this opinion? Is it truly the beginning of the end of democracy? Or is it the best solution among a bunch of bad solutions? I'd love to hear y'all's thoughts. I'll be down there chatting it up with y'all like always. But yeah, that is all I've got for today's video, so I will see you all on the next one.